Yep. Can you hear us, Senator?
Fantastic. Thank you very much. I can see you. Seeing you's not a problem. Well, now you're further away, but I can hear you. Look, guys, try the volume. How are you?
Can you hear us?
Yes.
Terrific. Oh, hang on.
I've got a great view of your table. Now I can see your feet. That's it. Stop. Whoa. That's it. Perfect. Right. Thank you very much. If anyone's listening, we're just getting the teleconferencing going right. Okay. Can I welcome officers from Fair Work Ombudsman, and please give your name and address of the capacity in which you appear today.
Yeah. Steve Ronson, Executive Director of Enforcement.
And Anthony Fogarty, Executive Director of Policy.
Thanks very much, gentlemen. Now, I will give you thank you for coming along, and I do want to give you the opportunity for an opening statement before we go to questions. Do you have one?
No, Senator.
Great, fantastic. Now, I've been very vocal on the conditions that are being exploited within the road transport industry. I have come and I've tamed my language to say that I don't think the Fair Work Ombudsman is financed well enough to do all the work that needs to be done. You don't have to comment. I wouldn't expect you to. But I did write to you, I think probably about 8 months ago or something, to ask what prosecutions had been done by the Fair Work Ombudsman. And there's some pretty staggering figures of the cases that you've been successful for. Underpayment of wages and that sort of stuff. But gentlemen, this inquiry is bubbling. It's bubbling over the edge of the frustration, and I'm not having a crack at yours, the frustration of the non-compliance within the road transport sector. Firstly, from underpayment of wages. And I'm told by a lot of drivers, it is so hard to try and get the money that they're owed. And then I'll come to sham contracting, which you guys have been very busy on, but I'm told it's just rife out there. So in terms of underpayment of wages, if I'm a truck driver and I'm working for a company and I know I'm not getting paid right because I've checked your website, and my boss says to me, well, sayonara, how do I recruit the money that I'm owed because he didn't pay me properly to start with? And I don't have the union backing me. How do I do that?
Yeah. So, Senator, Steve Ronson, Executive Director of Enforcement. Well, the first thing that the worker could do is obviously contact the Fair Work Ombudsman, either through via phone or via email. So there's different ways that we can be contacted, and the worker can request our assistance in several ways. The worker, if they are willing and able, they can provide their own names, their own details about their former employment status, and that would be considered a complaint that we would look into, that we would investigate. If they're not comfortable providing their names for whatever reason, sometimes there are reasons that workers want to remain confidential. They can provide a confidential, if you like, complaint, or they can do it anonymously. But let's just presume that they're comfortable giving us their name. In the last couple of years, the Fair Work Ombudsman's, if you like, invested a lot more in using the tool which is called a compliance notice. And these are notices available under the Fair Work Act. And the way they work is if the inspector begins the investigation and can form a reasonable belief, which is a fairly, it's a fairly moderate threshold, but if the inspector can form a reasonable belief that there's been contraventions of the award or the act, we can issue a compliance notice on the employer, in this case it would be a former employer, and require that they rectify the worker all his or her entitlements, and they need to provide us evidence of rectification. Failure to comply with that compliance notice is what's called a civil remedy provision, and we will take that employer to court for failure to comply with a compliance notice.
So, Mr. Ronson, and thank you for that. It seems very simple, but I have had numerous conversations with, and I understand I said to you, I've got the sack, I've left, with numerous truck drivers who have said that they just can't get anywhere. Then they're told to go off to the, and don't hold me on this, it's either the circuit court or the magistrate's court or something, but is it not simply a case, and I go back to the good old days of the Industrial Relations Commission and the state and the federal ones and that sort of stuff, but if a worker comes to you and they go, is this what they do? They come in, they say, hi, I'm Glenn Sturl and I work for Mongrel Brothers Transport, and here's what they pay me, there's my pay sheets, there's my work diary, my time sheets, you can see they're not paying me and I asked to be paid the award and they didn't. Are you saying that's just a simple case of you'll send an inspector out there, you'll go get Mongrel Brothers and you'll say, bring out your pay, your work, your records, and oh, geez, you're right, you have ripped him off. Is it as simple as that?
So, well, in a case like that, that would be best case. That's a case where the worker's bringing in documentary evidence.
Sure.
And it makes it a lot easier for the Fair Work Inspector to form a reasonable belief. Just in the case of, just to ensure that there's some sort of natural justice and due process, the inspector will put the allegations and provide the evidence to the employer to give them an opportunity to respond, just in case there's something that has not been disclosed. But in a case like you've just provided there, that would be, that would be the best case, easiest way for an inspector to issue a compliance notice.
Okay, so thanks, Mr. Ronson. So the inspector issues the compliance notice. Now, what if Mongrel Brothers Transport tells you to go away? What happens there?
So if we've issued a compliance notice on the former employer or the employer, and they just say go away, then they will be taken to court. So the remedy of non-compliance with a compliance notice is we take them to court. And so what we can do there's a fine, not just for non-complying with the compliance notice, but we would typically also sue for the underlying contravention, so we can get the money back for the worker.
All right.
Senator, it's Anthony Fogarty, Executive Director of Policy. Just to add to Mr. Ronson's comments, in the 2018-19 financial year, which is where we did start issuing or utilising compliance notices more than we have historically, around 96% of those compliance notices were complied with. So, to date, it's proving to be an effective tool.
So thank you, Mr. Fogarty. 96% of those compliances notices were complied, so the employer paid up. How long would it take? Firstly, how many cases have you had in that time that you gave me for the 96% success rate?
I've got the
Senator, a couple of thousand,
in this current financial, do you mean compliance notices generally, or?
I mean, I don't know what I mean. I'm just saying that I was just given a figure by Mr. Fogarty of 96% success rate, which is great.
Yes. Yeah.
For what period of time? How many complaints did you have that you acted on?
So, Senator, so in that 2019-20 financial year, that related to over 25,000 requests for assistance. Now, not all of those were compliance notices, though. That's 25,000, more than 25,000 that are workers coming to us requesting assistance. And in that year, we recovered $123 million in underpaid wages.
Oh, did you really?
That was a fairly significant year. That was 4 times the amount recovered in the 17-18 financial year, triple the amount covered in 18-19. So, I think it's fair to say that we're seeing an increase in recoveries via the use of compliance notices, but that's not all from compliance notices, obviously.
No, okay, but this is good news. So now the boss has said, go away, I'm not paying it, I don't know that so-and-so has sent. How long does it take? You'll take him to court, is that right? The Fair Work Ombudsman will.
Yeah. Yep. So the employer, that's correct. So the Fair Work Ombudsman will take the matter. Now the employer under the Act, if they're issued a compliance notice, does have the right to challenge the compliance notice, but to do so, they've got to apply to the Federal Circuit Court, and they've got to actually apply to the court. So they can't just write us a letter saying we're ignoring you or we're not going to pay your notice. They actually have to make an application to the court where we will contest the matter.
Okay.
So, and in terms of the time frame, we will look at the employer on a case-by-case basis, but typically a compliance notice can be complied with, I think the minimum is 14 days that we have to give the employer the opportunity to respond. But depending on, the situation and how much we're requesting is repaid, an average might be 21 days or 28 days that an employer has got to comply with the compliance notice.
Okay, that's good. So how long, and I'm looking at the recalcitrants who refuse to just think that they're not going to pay the money that's owed because they've gone out and slashed the living daylights out of someone else's rates so they could go pinch their work and take it out of the driver. But anyway, I digress. So if they go to the federal court, so within 21 to 28 days, you'll issue the compliance, and then sorry, you were about to say something?
Yeah, so what we would do, if we go back to the example you provided, we've got the worker come in, he's provided documentary evidence, we have a look at it, it looks pretty clear on the papers that there's been an underpayment of the rates or the act. We put those allegations to the employer, subject to what the employer says. If it's convincing or compelling and they can provide counter evidence, we'll consider it. But let's just say we issue the compliance notice, we seek the repayment of all the workers' entitlements. That normally as an average takes around, say, around a month and a half for that process. Then in the compliance notice, as an average again, we'll give the employer about a month to comply with. Now, during that period, the employer, if they want to continue the challenge, they've got to go to court.
Yep.
To take us on. Yeah.
Okay, so what's the worst? I've heard things have gone on for years, and I'm very well known. Sorry, that's bad English. I'm very well aware of a well-known case in Queensland with a company that starts with B, who have been going through this for years, and this was the sham contracting stuff. So if that's a different thing, I'll come to that in a minute. I do want to talk about that. But can this wrap up within a matter of months? Are we just at the behest of the court waiting list? What could it take?
Well, Senator, I was just going to add, it can be different depending on what tool or process we're going through. If it's an underpayment matter, a sham contracting matter, that we
I haven't got the... Sorry, Mr. Fogarty, I'm just talking about underpayment of wages. I do want to come to sham contract. I don't want to... Well, once I finish this, I'll go to sham.
I guess I'm trying to differentiate an underpayment matter that wasn't, whereas compliance notice hasn't been used, where it's an underpayment matter where we are pursuing underpayments and a penalty for, or breaches of the Act and penalties for those breaches through the courts, but not via the use of a compliance notice. Yes, the reality is that can be a long process. It involves numerous steps. It involves gathering of evidence. It involves witness statements, record of interviews. We need to have sufficient evidence to satisfy the court, which, as you would understand, they are reasonably high requirements.
Sure.
Necessarily so. So yes, those type of underpayments can take significantly longer, and yes, we are somewhat beholden to the courts and the amount of matters that may be in the pipeline.
So would it be fair for me to say that, let's look at last year, 1920, 96% of money's collected, 123 million. I'd assume there most of the employers said, yeah, hands up, you got me, and let's just sort it out, correct? That'd be about right?
So in terms of the where we have found and where we've got a reasonable belief that entitlements are owed, the overwhelming majority of employers accept the fact that we are correct and the notice is not disputed.
Yep. That's all right. Okay. All right. Now, when you get those, do you actually say, well, crikey, I don't think that one truck driver is the only one being ripped off? Do you then say, pull out all your records and we'll check all your truck drivers, all your forkies, all your staff? Or do you just leave it at the one and think job done and we'll move on?
Senator, the latter, not through necessarily lack of desire, but you're correct. Unless there is something suspicious or there is evidence indicating that the issues would be broader, it's more likely that the complaint that is brought to us is treated on its own merits.
Sure.
And we won't conduct necessarily a company-wide audit.
All right. Well, look, I don't want to put the hammer on you because you've got political masters to answer to. So if I ask a question that's uncomfortable, I understand when you say you have to refer to a minister or further up the chain or whatever. Is that a legislative fix? Can we fix that with legislation, or could it be just, look, it's resources?
It's probably more a question. I don't think it's necessarily... I mean, I can defer to Mr. Fogarty, but I don't believe it necessarily requires a legislative fix. We do have the powers to initiate audits of all and any companies for the purposes of ensuring compliance. It just boils down to the fact that there are 13 million workers, 2 million businesses, and only so many hours in the day. No,
you don't have to go any further. You can if you want, but I get that. Okay, that's answered that. Thank you very much. Now let's go to sham contracting.
Senator,
yes,
sorry, I should jump in just to say I don't. It's not always the case that we won't look at other workers. It's often we'll often see circumstances where we get a number of workers. It often goes through a workplace that workers will talk to each other and may then approach us as a group. And for us, it's about the access to the evidence and the efficiency of that. So often where we get a group coming forward, that it may be that we're looking wider across the workplace.
Okay, and look, I don't wish to sound like a smarty, but I know when I was doing it, you'd walk in there, you'd request nicely from the employer to bring out all the wage records. It didn't take long to work out. You could do that in a couple of minutes. Is that still the case?
It is the case in terms of audits. When we conduct audits, there's no question that we can request a sample of workers, we can request all the workers, and we can get the documentary evidence. We're still left with the same, we'd still apply the same tools, the same approach. So it would be, in the case of a company-wide audit or a business-wide audit, we'd issue a compliance notice. That's correct.
Okay, Senator, sorry, we should have probably differentiated that there's two streams to our work, which is reactive and proactive. And so we've been talking more here about the reactive, where we're getting workers coming to us for assistance, but there is also that proactive element where we are auditing.
Okay, that's great. Thank you. Now let's go to sham contracting, and I'm making this statement without any fear of retribution that sham contracting is rife. And we're uncovering it every single day. You can see someone advertising on Seek, and I know you've done some fantastic work. You've gone out and recuperated a lot of money. Tell me all about what's the process for sham contracting? One, do you find them, or do you wait for someone to tell you, or do you wait for someone to come and say, hey, I've been used as with an ABN and I want my money back? What do you do?
Senator, it's a mixture of both. As Mr. Fogarty's just stated, we have both a reactive and a proactive approach. So I think we've explained our reactive approach. When approached by, say, workers who allege that they've been underpaid, we respond. We've spoken about that. Yep. We've also, in sham contracting, because we have been funded to create a sham contracting unit, which we began just under 2 years ago. We're doing a lot more proactive work. We were slightly impeded in our field work during 2020 because of COVID, but we are at the moment implementing a sham contracting strategy that will see us for the next 2 years, and we're targeting 4 sectors in sequence: transport, healthcare, cleaning and support services. And they're 4 separate bodies of work which will occur not necessarily in sequence, they'll just begin in graded phases. And we have just begun, we're at the very early stages of our investment. The lights have gone out. We're just at the early stages of our of the beginnings of our investigations, our proactive investigations into a segment of the transport sector.
Well, this is music to my ears. Okay, so transport, well, it's sad actually, it's terrible, but it's good that you're doing this. So you have a sham contracting unit, and transport is one of the 4 industries that is targeted to kick off. May I ask what part of transport it is? Maybe it's all road transport to start with, is that right?
Yeah, it is road transport, and it's in the, I don't want to disclose too much at this stage because it's very early on, but it is in the area relating to, if you like, the best way of probably framing it without giving it away too much is online delivery. So in that space.
I'm very relaxed, very relaxed. That is good news. And how long will it be before we have some wins on the board?
The first phase of the investigation should take us around 3 to 4 months, all things being equal, and we're not sort of impeded by any lockdowns or COVID outbreaks. We have just literally last week entered the field at certain sites to begin taking statements from workers in what we are looking at certain target businesses and sites. So if our first phase goes well, and there's numerous companies involved in this first phase, we should be going for about 3 or 4 months. That will then give us enough or sufficient evidence to then work out what are the next steps. So in about 3 or 4 months, hopefully we're in a strong position to determine preliminary findings of what we've found in the field. Sorry.
No, I'm just going to say I'm looking forward to seeing your body of work. Carry on, Mr. Fogarty.
Senator, I was just going to say, so Mr. Ronson there was detailing the proactive strategy for supply chain. I should also point out that since we did receive that funding to set up the sham contracting unit, 1st of July 2019, so we've, in that reactive space, so for sham contracting and misclassification issues that are coming to us, we've completed 548 sham contracting disputes and recovered $423,000 for... Is
that just in road transport?
No, that is across the board. Road transport made up around 18%, has made up about 18% of those sham contracting matters.
Okay, all right. Well, I really am buoyed to hear that and looking forward to seeing. Hey, if you want any more examples, give me a ring. I've got them all. So let me just... Yeah, go on.
Sorry, I was going to say, Senator, I mean, the reality for us and how we set our priorities, we look at a number of different factors, including the number of percentage, if you like, of the requests for assistance that are coming to us. Mr. Ronson mentioned earlier, we have an anonymous report tool, and that's something that I think can be promoted through this inquiry, because we do have some sectors, and I don't know whether this is the case with transport, but some sectors where workers aren't as willing to come forward, but the anonymous report tool is a way where they can just provide details of where they think an employer might be underpaying, and in fact other businesses, if they think that their competitors aren't doing the right thing, can provide those details. And that's one of the main, we'll look at those sources of data as well as relevant ABS data, etc., to develop what we call a compliance risk model. Now, for road transport, the amount of requests for assistance and anonymous reports that we're receiving is about the size of the market that it makes up. So it's not disproportionately represented necessarily. So inquiries such as this can be very useful for us, because it may be that our data isn't representing all of the issues that perhaps exist. So we would welcome any referrals or information that you can provide.
Look, Mr. Fogarty, this is getting better all the time. So all the boys and girls out there listening to this, keep coming in, dob them in, keep it coming to me and I'll pass it on to the Fair Work Ombudsman, because clearly this is theft. And it's stealing food out of the mouths of decent men and women who are paying their staff properly. Not only that, also their staff are missing out. So I'll ask this tongue-in-cheek question. Have you ever had one complaint of sham contracting where you found out that they were overpaying the poor bugger who was shammed? I reckon I know the answer. There you go.
I need to take that on notice.
All right. Now, I really appreciate you guys doing this. This is just great news. Unfortunately, the sham contracting unit was the best kept secret until about 3 hours ago when the ATA mentioned it to me. So I'm really rapt to hear that. What I would do, without putting you in any, and I would not do this to you, but when there is some successes or this stuff that you could let out, could you let this committee know, please? When you can, not now. I know you can't.
Yeah, certainly, Senator.
Yep, no, that's fine. That's tremendous. Because this will be an ongoing body of work. The report will be done in the next month or so, but it won't be the end of it. Now, when you find out these sham contracting carries on that are going on, do you guys have the ability to say to them, why did you do this? Because I got one the other day and the perpetrator, the alleged perpetrator who was trying to sham contract, actually came back and said, my accountant told me I could do that. Have you heard that?
Senator, it is true that a lot of businesses in Australia get their industrial relations advice from their accountant, which may or may not be the best place to get their industrial relations advice, considering the Fair Work Ombudsman provides free advice and resources to every employer, plus a small business helpline, what have you. Just with respect to the first part of your question, it is very uncommon for an employer to admit that they've involved or engaged in sham contracting. What may be more common is that they might say, through lack of education or through what the accountant told me, I didn't know that I should have been paying that person under the award. I thought they were an independent contractor. I did not do this deliberately. So people will, some employers will typically say they've received advice,
sure,
and it could be from me. But obviously, at the end of the day, it's their obligation under the Act to comply with the law.
And yeah, that's right. And I will take that questioning up with the ATO, where that should lie there. Can I just ask you, without mentioning names, you have a high-profile case in Brisbane that's been going for a number of years. Is that? I think we know the same one. We're on the same one where there was a number of, I think they were courier drivers or small, medium rigid drivers that were sham contracted, and then of course the employers tried to pull every stunt out of the book. And I understand there's been hearings in Brisbane. Is that case still going?
Yes, so okay. I'm pretty confident we're talking about the same matter, and the liability hearing took place in the Federal Circuit Court in Brisbane last year, 28 to 30 September 2020, before Judge Jarrett. So it was over 3 days.
That's the one.
And His Honour has reserved his decision. It's not yet published.
Oh, okay. But what I do, and if you can't talk anymore, we're not mentioning names, but I believe that there were a number of other, I'll say employees because they were employees, who are also wanting to join the action. And I know at the stage that they couldn't at the early stage. Is there a possibility once His Honour has come forth and made his judgment and it's in the negative to the employer, can other employees jump on? Will you do that, or do they have to come to you and start all over again?
It would be, I think what we've previously said to those workers, or at least through their representatives, that subject to the findings of this decision, if the decision is in our favour and that there is a cause of action for the other workers, then the Fair Work Ombudsman would be more than happy to follow up on behalf of those workers. That might not require legal proceedings. It might be the case that we issue compliance notices based upon the authority of the decision.
But you would need those aggrieved employers to come forth and ask you to do that, Mr. Ronson.
Well,
Is that
yeah,
correct?
in terms of, yes, because in terms of issuing a compliance notice, for example, we need to be able to form a reasonable belief
All right.
that they were underpaid. So we would at least need, if not some documentary evidence, it would always help to have some,
Yeah.
you know, some other supporting evidence.
Sure.
It makes it a lot easier when you've got employee witnesses prepared to make the journey.
And I was going to go that to anyone listening out there, for crying out loud, boys and girls, keep a record of your hours. Okay.
Yeah, absolutely. Yeah.
Well, Mr. Ronson and Mr. Fogarty, I can't thank you enough. Thank you very much. That has been very, very informative. It actually, as we get later in the day, it's harder for me to smile, but I've got a smile on my face, and I'm looking forward to seeing the fruit of your efforts with the 4 industries, particularly the road transport industry, that you're now got some extra funding for to go off and clean up or give it a serious shake, this sham contracting. May I ask how long that bucket of funding lasts till?
Yes, and it was over the 4 years from the 1920 financial year, so 4 years from there.
Okay, so the sleeves are rolled up and we should see some good outcomes sooner than later. Mr. Fogarty, Mr. Ronson, thank you so much for your time, and I appreciate that evidence that you've given in the fine work. Thank you.
Yeah. Thank you, Senator.
Thank you very much. All right, now what are we doing now? Smoko. Is it Smoko? It is. Okay, we'll now have a 15-minute suspension and we shall return at 10 minutes to 4. Thank you. Hey, how crook is COVID? You can't even get...